So the first thing I have for you right out of the gate, talk to me, why is this something that you guys are pushing in an appellate court to move forward to make this something that doctors can do?
This is an extremely important issue for patients and doctors alike. We all want to have good deaths, and unfortunately, there is some suffering at the end of life which simply can't be controlled, so that people should have options available to them at the very end of their lives, which they can use to have a peaceful death. Aid in dying is just one of a number of options which can lead to a peaceful, dignified death. It is the process by which a terminally ill patient can obtain a prescription of medicines which the patient can take at a time and place of his or her choosing in order to achieve a peaceful death when their suffering becomes intolerable.
Now, I talked with, of course, the chairman of the New York State Conservative Party, and he, of course, says that this is assisted suicide.
Oh, he's absolutely wrong. This is in no way a suicide. Suicides are committed by people out of desperation, in isolation, people who could continue to live. For people who are dying, this only just one other in terms of peaceful death. They can have life-sustaining treatment withdrawn. They can voluntarily stop eating and drinking. They can be sedated to unconsciousness and have life-sustaining treatment withdrawn, a process called palliative sedation. So this is really so much different. This is something which is a process which is engaged in with a doctor and the patient, almost always with support of family members. The process usually takes some 47 days between the time that the patient requests the medications and the time that they actually take the medications, if they do so at all, and about 30% do not do so. It's rarely used, about 1 in 300 people, but it's important to know that people have the option available to them. So it gives great comfort to thousands of other people, or tens of thousands really, who are dying, just to know that they have this option available to them. It's so much different than a suicide. It's insulting to patients and to their family members, people who have really had a long life for the most part, who would want to continue to live but simply cannot go on living.
I'm going to grab part of that connection was a little weak and came back now. You're good right where you're at. Just again, to those that say this is assisted suicide.
This is in no way a suicide. Suicides are committed by people out of desperation who could continue to live, almost always in isolation. Aid in dying is a process which people go through where they are terminally ill, they're going to die, and this is just a choice that they are making in terms of how they are going to die. People can die by other means, such as having life-sustaining treatment withheld or withdrawn, a feeding tube, a ventilator, dialysis. People can have a cardiac device deactivated, and so forth. This is a process which involves a physician who has to prescribe the medications with almost always family support, and it's a process which ordinarily takes some weeks between the time that the request for the medications are made and the time that the patients actually take the medications, if they ever do. And about 30% of patients, in fact, don't take the medication. Suicides are tragic. Aid in dying is really a process which empowers patients and family members alike. It is in no way a suicide. And that terminology, by the way, has been rejected, assisted suicide language, by the American Public Health Association, the American Medical Women's Association, the American College of Legal Medicine, and the American Academy of Hospice and Palliative Medicine. So this is really not a suicide, and it's insulting to patients and family members alike to characterize this as being a suicide.
So next, I guess the next step at this point, this is something that I mean, in terms of your side of things, do we have to, when do you guys have to file?
The appellate division is now considering our appeal from the dismissal in the lower court, and the case is likely to be heard by the appellate division in February. We are relatively confident that we will succeed in the appellate division because we think that the decision by the lower court was wrongfully decided, where she did not take seriously our constitutional claims as well as our statutory claims, nor did she hold an evidentiary hearing where she could have heard testimony from both plaintiff patients, people who are suffering and are near the end of their lives, as well as a number of doctors, including Dr. Timothy Quill from University of Rochester Medical School, among other highly respected doctors who are supporting and are involved significantly in this case.
And the argument in your side of things, in terms of, this is something that they should legally be able to do, and the argument, it was thrown out. Why was it thrown out in the lower court?
The lower courts really looked to a decision which was rendered by the United States Supreme Court in 1997, raising similar issues, but that decision was rendered at a time when there was no evidence which showed that aid in dying works just as intended in states which now have 18 years of experience, for example, in Oregon, and 7 years of experience in the state of Washington, where no problems have arisen. At the time the Supreme Court rendered its decision, it had legitimate concerns about vulnerable populations, such as poor people, people without insurance, people with disabilities, and so forth. However, studies have shown that there is really no disproportionate impact on people with vulnerable populations, and the law has worked just as intended. People, in fact, for the most part, are well educated. Almost everyone has health insurance, but we know that suffering simply can't be controlled at the end of life for some people, and so even though about 90% of those who take advantage of aid in dying in the state of Oregon are receiving excellent hospice care, their suffering still is too great for them to continue to live, and they do at some point. A very limited number of people, about 1 in 300, ends up taking the medications to achieve a peaceful death.
And again, this was. Do you have a copy of this you can throw to me? A copy of the first decision, or a link to it that you guys are? I know you're involved with it along with a couple other doctors. Do you have some cases that you can get me in touch with?
What I'd be happy to do, of course, is to send you the lower court decision and our appellate brief.
Yep.
And I can put you in contact with some of the doctors involved in the case.
Sounds good. Anything else on this that you want to add?
The only thing that I would add is that there are no good arguments which would prevent a terminally ill, mentally competent patient from being able to take these medications. The arguments on the other side of the issue simply don't have merit, simply do not wash at this point, and this is particularly true based on the experience in Oregon, Washington, as well as now Vermont and Montana, which do have experience with aid in dying, and their experiences are extraordinarily positive.
And you want your day in court to explain that?
We want our day in court to explain that, and we do think that ultimately we will be successful, and that fortunately in the relatively near future, aid in dying will be legal in New York, as it is now in several other states, just most recently in California, where the legislature passed a bill and Governor Brown signed it into law.
Okay, yeah. If you can shoot me those cases, that'd be great.
Okay, I'll shoot you our appellate brief, which has a lot of cases, and also I can give you a couple other names of contacts people who are involved in the case, in addition to Dr. Quill.
That'd be great. I appreciate you doing this for me.
Okay, well, thank you very much, and Do you think it'll be airing today, or?
I'm going to work on it. We'll see. But yeah, we will go from there.
Okay, thank you very much. Nice to talk with you, Nick.
Thank you.
You're welcome. Bye-bye.